Okay, that number seems to be stabilizing now. So I think without any further ado, and because we've got a full session this morning, let's kick off. Good morning, everybody. Thank you all for taking the time to log in and join us this morning for our February hospitality webinar from ourselves here at Moore Kingston Smith. For those of you who don't know me, my name is Peter Davis. I'm one of the partners in MKS, and I'm also the head of hospitality services. And many of you will also know me as the trunk master as well. But thankfully, there is very, very little of that today. Let me introduce to you my colleague who is here and to be honest is going to be doing most of the heavy lifting this morning. So, Claire.
Yeah, good morning, everyone. I've just actually realised my job title is wrong in the slides, so that's my wrist slap for not actually checking the slides. But yeah, I joined Moore Kingston Smith about 6 weeks ago now as Director of Hospitality People Services. Supporting Peter in the trunk team and supporting the rest of the hospitality and leisure division, providing people support for all our clients.
Super. And for those of you who may not know, Claire is far too modest to say, Claire's a very, very experienced HR professional and has worked in the hospitality sector for many years. I've known you for a dozen years or so.
Yeah, I think it's more
Yeah.
than that, Peter, but
I'm too young for that, Claire. I'm
we
too
have
young.
worked together for
Um,
many years.
Indeed. And Claire's previously held leadership roles within Casual Dining Group, or Big Table as they now are, Flatiron Steak, Aqua Restaurant Group, and others as well. So safe to say, knows her stuff and has been there and sat or stood in the shoes that many of you will be standing in as well. Just a little bit of housekeeping. We are going to hopefully have some time at the end for Q&As. So for those of you familiar with Zoom, there is a chat Q&A button at the bottom. Please put your Q&As in there and we will try and get to them a little bit later on as well. As you can see, we've got an agenda here. There is no test at the end. Please don't panic. But we are going to engage in a little bit of audience participation, tech permitting, but I'm not going to give all of that away now as well. I think it's safe to say that this is the biggest change in worker rights for a generation. It's a really, really important subject. And as hospitality is a sector where people really are at the heart of it, it's really important that to us that you as our clients and other businesses feel fully informed and ready for all of this. So with no further ado, I am now going to hand over to Claire, who is going to gently guide you by the hand through the mists and the fog of the Employment Rights Act. Claire, over to you.
Yeah, thank you very much, Peter. So yeah, I mean the agenda's up on the screen at the moment. So we're really take you through very, very quickly the key dates because there's lots to get through. The key changes that are certainly affecting businesses this year. This is over 2 years we've got. So it became law in 2025. And a lot of the measures are coming in 26, 27. So we're going to go through those really on the grounds of what is going to affect hospitality businesses the most. And that's why you're here today. So in terms of what Peter said, in terms of interaction, we're going to start with a poll. And really just to temperature check the room and see how we go with that. So yeah, tell me if you can see on here, how are you feeling? Are you confident? You sort of know what's going on, some awareness, and you weren't really aware at all. And thanks, we've got some great participation coming up so far. There's no right or wrong answer. It will really help us understand where the room is at the moment. So we've got about, yeah, 74% participation. That's fine. Great to see some people are really confident. That's great to see. So I hope I can share something with you that you might not know already. And for those of you that are kind of sort of confident and have some awareness, great. That we can, impart some of our knowledge. So just going to end it there. Thanks for your participation and just yeah. So we had, confident, vast majority of some awareness, which is great. And we had a couple of people kind of going, wasn't aware at all. So brilliant. So that's why you're here. So key dates. Obviously, you will get a copy of this recording and you will get a copy of these slides. So don't worry about rapidly writing things down or taking notes or taking pictures. So as I said, back while we were enjoying all our Christmas parties and serving guests and making sure they all had great time, the king finally was given the bill to grant his royal assent, and he did that just before Christmas. Probably went under the radar for a lot of us. Immediately, actually, after that, after it became law, there were a number of trade union changes, which I'll take you through. And certainly from about February onwards, it's worth noting that the paternity leave change that comes in place in April, those with a day one right can now start to give notice to take paternity leave. And we'll come on to a little bit about that in a little while. So from the 6th of April, there will be further trade union changes, changes to statutory sick pay, paternity and parental leave changes, protective award on collective consultation will lengthen, whistleblowing definitions, and the establishment of the Fair Work Agency. Then from the 1st of July, now I've popped that in, often it gets overlooked a little bit, but with the changes to unfair dismissal from the 1st of January in 2027, anybody that joins your business from the 1st of July and is still employed on the 1st of January when the unfair dismissal rules change, they will be able to claim unfair dismissal from the 1st of January. So that 6-month ruling will affect anybody that joins your businesses from the 1st of July. And again, I'll explain more on that. October sees another raft of a big list, so changing to tipping rules, provision on third-party harassment, sexual harassment prevention, employment tribunal time limits, and further trade union changes. We then move to 1st of January 2027, as I've already mentioned, with unfair dismissal is being allowed after 6 months. That moves from currently 2 years, and that will move to 6 months. And there will be restrictions on the fire and rehire practices. And then in 2027, as if 2026 wasn't enough for HR, we're going to have a raft of other changes affecting 0 hours, big impact on hospitality, certainly, flexible working, notifications of shifts, pregnancy protection, bereavement leave, collective redundancy changes, gender equality, gender pay, and menopause action plans. So, it really is a big couple of years for employers and HR teams. So let's talk trade unions. So the immediate change, as I said, when it became royal assent back in December, the notice to strike reduced from 2 weeks to 10 days. Now, this in itself impacts us as a hospitality businesses, whereas before, we'd have at least 2 weeks to prepare. We'd know about strikes. It now reduces to 10 days. And then in February this month, protection against unfair dismissal if an employee takes part in strike action. As we know, the Labour government were always going to do a lot for trade unions. So again, and put a lot in the make work pay. So these are some of the measures that kind of impact. In April, there's changes around recognition and levels required for ballots for strike action. And then in October, so this is the big one, businesses will have a written requirement to inform employees of their rights to join a trade union. And unions will have the right to access workplace. Now, there was a consultation on this. It was ran between October and December of last year. Blinked and we missed it. So there's no way of us, making any kind of written requirement for the government to consider how these written requirements to inform employees of the rights to join a trade union or how the access to workplaces will work. The government are now reviewing that consultation, and unfortunately for us, I think it's very much okay. We've got to wait and see of the output of that consultation. It could be a line in handbooks or contracts to say you're entitled employees to join a union, but as I say, we don't know that. So we need to wait for the outcome of the consultation. I think when we talk about trade unions, they already can access the workplace to attend disciplinary grievance and appeal hearings. There's nothing new here, but what we would suggest that you do, remain calm, remain confident when dealing with trade unions. It's being about being prepared and not being defensive when you talk to trade unions. Think about ahead of the results of the consultation with trade unions. Look at your contracts, look at your handbooks and offer letters about what is written in there with regards to trade unions. Often, in small, medium businesses, you don't hear a lot from trade unions unless, of course, it's disciplinary grievances. But obviously, our bigger firms out there will already probably be engaging with trade unions already. And again, it's about being prepared and not defensive. So perhaps start to think about engaging with the trade unions themselves. So you are on the front foot rather than the back foot when the likes of Unite and GMB come looking. So day run rights. So we have a lot of short service employees. There's our retention at 90 days. As an industry, is around 35% I learnt yesterday actually at the UKH workforce event. So yeah, we have a lot of short-serving employees, and if one of them joins you and immediately on day one says, I need some paternity leave in 2 weeks, it becomes a problem. You know, you are you know, if you've got long-serving employees, they will probably proudly be talking about, you know, their next child or their new child, and you will know months in advance when they're going to want to take their paternity leave. But you know, with this becoming a day one right, and as I've said, notice can be given already in February to take paternity leave. You're not, as businesses, able to plan ahead. So, you know, think about again, you know, all your policies and your handbooks and your contracts, you know, they need to be changed to, you know, reflect the day one right to paternity leave. Interestingly enough, the right to paternity pay, there's still a qualifying period, and that remains at 26 weeks service. Unpaid parental leave is now will be a day one right from April, along with bereaved partners' paternity leave, and the removal of prohibition on taking paternity leave after shared parental leave. So that all comes into play in April. Think about your onboarding packs. Think about and you know, as I've said, you know, how do you react as businesses to absences from short service employees? Got to be agile and you know, ready for them to suddenly request that. So probably one of the biggest operational impacts for hospitality. So statutory sick pay from the 6th of April, statutory sick pay will be payable from the first day of sickness. This is a change from being paid after from day 4. This is now being paid on the first day of sickness. Also, the lower earnings limit removal, which widens the scope of those eligible for SSP. So this means, you know, SSP will be paid regardless of earnings level. And, you know, this is, you know, the government's commitment to make work pay. You know, 1.3 million employees will now newly be entitled to statutory sick pay. They will be paid statutory sick pay at either a rate of 80% of their normal weekly earnings or the flat rate, whichever is lower. So, you know, for hospitality businesses, or any business really, you know, but for hospitality, you know, most short-term absence costs, it's far more disruptive than perhaps those on long-term sick. Think about your tolerances. So, you know, how as a business and what's the trigger points for you to manage short-term frequent absence? You know, there's trigger points such as, you know, 3 separate periods of absence over a rolling 3-month period. Is that acceptable? And how as businesses are you going to work that through? Obviously, yeah, again, you know, look at your handbooks and look at your policies, particularly around how you manage return to work, how you are managing short-term frequent absences. Have you got robust recording systems? And how are your teams managing return to work interviews? You know, this is a huge thing. And when I talked previously about, you know, retention, when we talked about day one rights and, you know, paternity leave, Absence is often the early warning system for those that are going to leave and shortly resign. So, yeah, any extra cost on your rota is a problem. And look at the pattern absences. Have we got frequent people that are on a second Monday of every month? Have those conversations, but whilst you have those conversations, make sure your policies are in place to allow you to have those conversations, and also your reporting structure. And whether that's on your HRISs, on your payroll systems, or I've worked in the past with spreadsheets, and you're recording every single day of absence, and then your patterns can work it through. Think about your tech that you've got working in your business. Is it working for you? Is it fit for purpose? And also, again, your managers. A lot is going to fall on them. So have they got the help and support from people teams, from operations, to be able to be having those potentially difficult conversations with any employee that's short-term frequent. So as I said, it's probably one of the biggest impacts on hospitality. So in terms of finances, what does this whole low earnings limit or 80%, what does that actually look like? So I've got a couple of examples. So you had a low earner working part-time, average weekly earnings of about £90 per week. Before April, they wouldn't receive any pay if they went off sick for 1, 2, or 3 days. And now, obviously, they're eligible for SSP and they're eligible from day one. So the lower earnings limit is removed. So 80% of £90 is 72, and it's the lower of the two figures. So statutory sick pay at the moment is 123.25. The lower 72 is that lower figure, so that's what's going to be paid. £72 over 5 days, or divided by 5 days, is £14 a day. So £14, when you rack that up over several days or several employees, that's your cost mounting. Average earner on about £150 average earnings. 80% of 150 is 120, and they would get that because it's the lower of the two. And that's again £24 a day if they're absent. And then a higher earner on, say £400 a week, average weekly earnings. So 80% of that is 320, but statutory sick pay at the moment is 123.25, and therefore that's what they will get. And from day one, they will start earning 24.65 a day. So again, you can see the implications and the costs coming up here. Our next one, so Fair Work Agency. It is not active for a number of months. It comes into force at the beginning of April, but they haven't yet worked through the processes and when they can really start cutting down or clamping down on businesses. But what it is going to be about is this single enforcement body for workplace rights. It's going to be able to investigate companies and businesses without even receiving a tip-off or a complaint. It's going to put the burden on proof on employers. It's going to enforce the employment laws, and it will be the central point of contact for issues such as wage underpayments, unlawful deduction of wages, holiday pay, national minimum wage breaches, and statutory sick pay breaches. they're going to be able to issue immediate fines, and they will be providing legal support to employees, and they can bring a tribunal claim on behalf of the employee with or without the employee's involvement. So I think, again, that's a real watching brief on this agency. And as a hospitality businesses, we're already frequent pressure points around payroll, trunk, holiday pay, national minimum wage. Spotlights are already on us. So it goes without saying. Review all your employee processes, including payroll. Look at the discrepancies now, and remember to where possible, resolve all these grievances and complaints internally before they go out to before they obviously lead to tip-offs or complaints to the Fair Work Agency. Try your best and your hardest to resolve those grievances internally. And obviously, if needed, you kind of seek some advice, certainly around and payroll and HR if you've got no in-house HR. Don't wait for an inspection. Don't wait for a Fair Work Agency employee to maybe just stumble upon your business and decide, they've got nothing to do, let's go in and go and inspect them. Unfair dismissal. So again, we've mentioned it already. This is a huge shift for us in hospitality businesses. I had a conversation this week with one of my clients that I'm helping through an investigation and a disciplinary process, and it was along the lines of, it's okay, they've got under 2 years service. We're not at risk here, and we weren't anyway because we were following correct processes, but it's always been that, oh, they've got under 2 years service, we can do, we're doing all right here, and we do, as we rely on this 2 years. So from the 1st of January next year, the qualifying period for bringing an unfair dismissal claim will be 6 months, not 2 years. And as I said right at the beginning, when we went through the timeline, this is backdated to the 1st of July 2026. So going on, unfair dismissals are only fair for one of 5 reasons. And let's just remind everyone, misconduct, capability dismissal, redundancy, statutory restriction, or some other substantial reason. So what should you be doing now? Certainly before the 1st of July, is again looking at your policies, your contracts, particularly around the probationary period. A lot of businesses do have 6-month probationary periods. So have a review on your probationary policy and how you are following that through. What's the practicalities around signing off somebody when they complete their probation? Are you looking for those early warning signs, within the first couple of months to actually realize that they're not going to work out for you? You need to review your conduct and performance improvement processes. And again, a lot of impact on managers, but it's identifying those early performance issues from very early on. Ensure your expectations are set out from day one. Make sure, as I would be saying anyway, record all conversations regarding performance. And again, have this clear probationary policy timeline and understanding when probation ends. And if you're going to extend probation period, make sure you're telling them early on in the process, and not the day before they're expecting their probation to be signed off. So there's a lot to unpick. And again, I would advise doing this before the 1st of July. Fire and rehire. Often used in hospitality to change roles or hours or pay structures, but it will be automatically unfair unless the company is in dire financial risk, and the changing of these terms and conditions would be unavoidable to keep the company viable. So this is coming into place at the beginning of January next year. It interestingly was moved from it was coming into place in October, and it's got shifted back a little bit. But it just means that you need to be having those, looking at people's contracts, making sure that they're fit for purpose, they're fit for the teams, they're fit for employees, and have that consultation. And it must be genuine when you are, and genuine and meaningful when you're talking to employees about potentially changing their benefits or changing pay structures, and they should be planned early. Because this fire and rehire, how a government or the Fair Work Agency are going to decide on a dire financial risk, again, remains to be seen. So yeah, review contracts and consider changes now, and ensure that you're making any kind of consultations meaningful and transparent. So you've heard a lot from me so far, so a little bit of audience participation, if you are up for it. I'm just going to launch another poll. And it's not going to allow it. So there we go. Peter, you were proved right in terms of tech.
I so hoped I'd be proved wrong. I did say polls were just asking for trouble here.
Me too. Me too.
Yeah, but as long as you've got the slide with the questions on the screen, people can look at that and see where do I think I fall in on that as well.
We can, but it's now not moving. So this is real life tech. But she's brought it back. We're okay. But we're okay.
I had every confidence in you.
No, we're going to skip the polls because it's never going to work now. But it was really along the lines of, have you got confidential helplines for whistleblowing, for confidential guidelines for your employees to speak to managers or make complaints and grievances around kind of any form of sexual harassment. So I have skipped a couple of slides, and I'm not going to try and play around and try and get them back. So with the whistleblowing law is changing in April, and sexual harassment complaints will now be treated as protective whistleblowing disclosures. And this obviously raises the stakes quite significantly. And then from October, employers will have to take all reasonable steps to prevent sexual harassment. So back in October 2024, there was the new law passed that employers had to take reasonable steps to prevent sexual harassment in the workplace. This will now change in October to taking all reasonable steps. And additionally to that, there will now be the reintroduction of employer liability for third-party harassment. So again, what does this mean? I mean, this is a huge, again, impact on hospitality. Yeah, it's a really important one. With alcohol, late nights, customers, close-knit teams, the risk profile is probably highest than many other sectors. So actions to take now. Review your policies, your contracts, including these whistleblowing helplines. People might say they've got, these sentences in their handbooks, but are they actually operational? Is there a clear process for complaints from your teams? Look at implementing risk assessments. Look at the risk involved for your teams. And train not only your team, not only your managers, but also teams, also your team members, on all kinds of harassment, with clear guidelines on what to do in the event of harassment. Can you show as employers that you've taken all reasonable steps to prevent this? And it's going to be on us as employers to show that we can take all reasonable steps. And consider this third-party support with whistleblowing helplines, or when dealing with grievances and complaints to ensure confidentiality. We work with a lot of small businesses that we're talking to the general managers and then perhaps a director, and that's it. What's the line when employees want to make complaints and raise grievances? So just a bit of training or a line in a contract or a handbook is no longer an option.
Well, it might be useful. You and I were talking yesterday about this, weren't we? And I posed the scenario of you might have a team member working behind the bar in a business, and on the other side of the bar, there may be a couple of customers who are engaging in conversation which isn't specifically aimed at the team member, but perhaps makes the team member uncomfortable, or in some way. So, as a business, what would your responsibilities be in that sort of scenario?
I think again, it's training the teams to understand what the processes are in terms of if there's something that they don't like, and having that clear. So they've got a clear confidence that they can go and talk to their manager, explain that they don't particularly like the conversation that's happening at the other end of the bar. And for the manager to again feel confident that they can talk to the customers, not necessarily throw them out, not necessarily tell them anything wrong, but more about okay, can you keep the volume down? You're making my employees feel uncomfortable. And
So,
it's
sorry, go on.
as I said, it's about clear guidelines in what employees should do, so they don't feel that they are embarrassed, or they're not going to get victimized if they make complaints.
So it's important, maybe if I'm an operator, that I'm going to need to make sure that whoever my senior team member is on duty at any particular time, that they're fully aware of this, and that they have the training on this, so that other team members who may be faced with this sort of situation, are clearly going to have to raise this in real time, if you like, as well. So, really, it's something worked by all managers and all more senior team members are going to need to understand what their obligations on behalf of their colleagues are.
Yes. Yeah, absolutely correct. Peter, over to you on tipping.
Right, I'm not going to run the risk of running a poll, but I'm just going to leave the slide on the screen and talk through it. See, learning from others here on that. So, look, I'm not going to run a poll on that, but my question to all of you is, number one, were you aware that there is a consultation on tipping? Hopefully, those of you who joined our client webinar a couple of weeks ago will know all about it. And number two, have you responded? Are you intending to respond? And if not, why not? With that. So, for those of you who weren't on our webinar a couple of weeks ago, a small but important part of the Employment Rights Act introduces some changes to the Allocation of Tips Act that came in October 24. And essentially bringing forward a part of the Labour Party's manifesto, which was that workers should receive all of their tips and should control how those tips are dealt with. Now, the last government took care of the first part of that through the obligation on employers to share 100% of the money with staff. The government appears to be slightly watering down the second part of that about handing over control of tips to workers. But what the government is very definitely doing is wanting to increase the involvement and voice that workers have in all of this. So there is a new obligation which comes in from the 1st of October this year. And what that says is that when you introduce a new tipping policy for the first time, you must have a formal consultation with your workers. And if you've already got a policy in place, because you've got one in place on the 1st of October 24, you must have a formal consultation on that at least once every 3 years. So for most people, what that's going to mean is that first consultation will need to be done somewhere by summer 27 at the latest with it. Now, what the government's current consultation is about is exactly what form these staff consultations, lots of C words here, should take, and also whether or not the government should make changes to the code of practice to either clarify or to go further in certain areas above and beyond what's in there already. Now, I'm not going to run through all of the questions in the consultation this morning, but they are addressed to consumers, they're addressed to operators, they're addressed to workers, and they are addressed to worker representatives, i.e. trade unions. And there is quite a big theme running through all of this, that where there are trade unions in a workplace, and of course, for the reasons that Claire talked about, that might be in more workplaces in 2027 than it is today, then they will have to be involved in this consultation. And it has to be genuine. Now, what the government has already said is that a business is not going to be obliged to act on all of the opinions and the views that are expressed in those consultations, but an employer will have to give their staff a written summary of the consultation, including the various points that may have been raised. And there is a clear inference that if a business or a trunk master isn't going to take those opinions on board or isn't going to act on those, then essentially the business or the trunk master is going to need to explain why. Why are we not doing that proportion of team might ask for as well? I think the key message here is when the government last did a consultation on tipping, they got a grand total of 159 responses from people connected to the sector. Now, some of those will have been from trade bodies, some of those will have been from people like me, some of those may have been from operators. The problem is that I can probably name who about a third of those responses came from as well. the sector didn't engage with the last consultation. And what that means invariably is if we don't engage, our voice is going to be drowned out by the voices of others. And by others, I mean those who may want a more fundamental shift in things. The unions see this consultation as their best and last opportunity to wrest control of this from employers before the next general election. And you don't need me to tell you how damaging it would be if they were to succeed in that. So I think it is really important that businesses make their views known in this. It's critical. We'll be responding clearly as professionals in this area. I know the trade bodies will be responding as well, and I talk regularly with them, particularly with UK Hospitality, on that. But it's important that you as businesses respond. It's also important that you all respond as individuals because you're also workers in your business. And on the occasion you may go and eat somewhere that isn't your own business, you are also consumers. And your own views as individuals are equally as important and equally as valid here. The consultation was issued on the 5th of February. It runs until the 1st of April. Now, for those of you who are clients, we're going to be circulating something today, actually, drawing out some of the key questions in the consultation, and giving suggestions, as to the sort of points that you may want to make in responding directly to the Department of Business and Trade. But I can't emphasise enough, it is absolutely crucial that all of you make sure your opinions on this are put forward. I think all of us had some misgivings about the allocation of TIPS Act. All of us would say that there were some aspects of it that we may not have liked. But I think the truth of the matter is that the industry has adopted it, has abided by it, has tried to make it work, and has acted in good faith. And I think it's really, really important that the government understand that. And the government understand that whatever issues there may or may not have been in the past are in the past, and that there is no need to go further. Clarifications if you must, but actually one of the good things about the Code of Practice at the moment is it is not prescriptive. It's wide enough and it's flexible enough that businesses can work in different ways. They're all working to the same principles and the same standards, but they can work in different ways. And so, that's important. We don't want micromanagement. That won't work. And again, it's really important then that the flexibility that the current code gives us is retained. So my strong encouragement to all of you would be to get involved. Like I say, if you are a client, we'll be sending something out later today with some pointers on that. If you're not a client and you are concerned, and you're also concerned about maybe the tipping policy or trunk rules that you have in place at the moment, we're happy to have a quick review of that policy with our team of experts here. We're not going to charge for that, just to either hopefully give you some reassurance to say, okay, this is going to pass muster, or if there's anything there where we might say, you might struggle defending this if you were challenged. We are aware of a number of individuals in various businesses who've gone to ACAS. There hasn't yet been any employment tribunal hearings on the TIPS legislation, and given the backlog that employment tribunals have got, there aren't likely to be any time soon, but it will happen. It's unlikely to be the end of the matter. So again, really, really important. Please do get involved with that. Back to you.
Yeah, thank you, Peter. So again, this would have been really interesting to see the results of this, but tech is fading and failing us. So we've gone through a lot this morning. And I think I was saying I've lived and breathed the Employment Rights Bill and the Act for probably about the last 6, 9 months. So, if we could have a show of hands, we could, but we're not going to worry about that. So we've gone through the power to the trade unions, unfair dismissal qualifying reduced to 6 months, statutory sick pay changes, tipping, the changes to sexual harassment, Fair Work Agency, or something else. Now, yeah, so something else. There is more. There's a lot more coming. The majority of it subject to consultation in 26, 27. Employment tribunal claims, the timeline is going to increase to 6 months. So, employees have a lot longer to decide whether to bring tribunal claims. And us as employers, we've got to keep our records and everything for a lot longer than and be ready for that kind of 6 month and 1 day breath of sigh of relief rather than the 3 months. So as I said, there's a lot still subject to consultation this year. Flexible working rights, collective redundancies. They're looking at combining multi-sites when you're dealing with redundancies, which could affect a number of our businesses out there. And the big changes to 0-hour contracts, the right to guaranteed hours, with how this is going to be calculated, what thresholds they're going to use, what qualifying periods, again, subject to consultation. And we will be running a separate webinar on specifically 0 hours, the right to guaranteed hours, and the notice for cancelling shifts or changing shifts. But again, this is one of the big headline grabbers of the Employment Rights Act, very much along the line of, 2 million are going to benefit from the changes to 0-hour contracts. So it has warranted its own webinar. Otherwise, I think these webinars would be a deep dive into the impact on 0-hour contracts. So please stay tuned for that one. And even more, so there's 2 slides on the even more. There will be a requirement in October or in 2027, excuse me, to publish both gender equality and menopause action plans for employers with 250 plus employees. The statutory compensation cap on unfair dismissal will be removed, raising minimum consultation to 90 days for 100 plus redundancies, further enhanced protection for pregnant and new mothers, and broader bereavement leave. So again, as I've said, a number of these warrant their own webinar in itself. And as soon as we get the consultation documents, we'll let everybody know. So if I was to take a summary and try and summarize everything that we've talked about in the last hour, and thank you to those that are still with us. There's been a lot to get through. It is the biggest legislation change in generations, and it's as I've said, doing these conversations, the last couple of months, it's no need to panic, because these measures are being phased in, but there is a lot to do. Please, there's over 20 consultations, either out there or due to be out there. So please do engage with them, particularly that as Peter said, the tipping, and then when the 0-hour contract consultation comes out, please do engage. communicate with your teams about all the changes. Let them know that you're well aware. Policy, statutory sick pay going to affect them. It's all in a positive way. Maybe use this opportunity to remind them again in a positive way about absent procedures. Having those wellness conversations before they actually get to be a problem. Think about your employee forums, your employee groups. Think about how you communicate with the teams and do it nicely. Great. All of this is going to benefit them. So please do talk to them and use this time to communicate with them. I wouldn't be an HR person, if I wasn't saying and recommending that you amend and update your people materials and your policies. And we've talked about a lot this morning about the expectations on managers. And there is a lot more for them to be doing as all these rafts of law changes come in. So invest in the training of your managers and identify where some of their capability might not be up to speed just yet, and identify where that support is needed. But also when you look at the absence, for example, look at your tech stack, to support managers, and ultimately they're here to give the best guest experience. And the more advice you can take from your tech, or more advice from independent advisors such as ourselves, we can help continue to give you to get your managers to give the best guest experience. So as we've said, we're here. You don't have to do this alone. And I think just have a look at how we can help as well, in terms of supporting your managers and supporting your HR teams as well in delivering some of these measures.
Brilliant. Claire, thank you very much indeed. Now, I'm going to now for the fun bit, which is the Q&As that we've got for that. So I'm going to go through those and try and read them off. Not seeing any on tipping, unfortunately, so I think that all means they're for you. I'm sorry. With that, okay. Okay. First off, are part-timers on student visas entitled to join trade unions?
Oh, wonderful question. Without knowing the consultations that the government have received and how this is going to work in practice, I would like to say yes, but I think we will come back on that one. I think we're gonna take away all the questions anyway, aren't we, Peter? And any that we can't answer, we will issue out to everybody.
The consultations that the government has already run, the ones they did at the back end of last year, do we know when to expect all of the results? Have we been given a timeline or not as yet?
Of course we don't, Peter. As I said,
I asked in hope more than expectation, but
I was at the UK event, a UKH event yesterday, and we had a member of the Department of Trade, the Business and Trade there. He acknowledged that the consultations had closed. Did we get a timeline? No, we didn't. But
next one. Does the statutory sick pay change apply to 0-hour contract staff as well as permanent or full-time staff?
Yes, it will. So, yeah. There isn't a long answer on that. Yes, it will.
Okay, that's easy. Okay. Would you need a self-certification certificate to be able to process SSP?
It depends on your payroll system. So up to the first 7 days of absence, you need a self-certification form anyway. So you should be processing SSP from day 4 with a self-certification note.
Okay. Uh, Another one, and you're going to kick me for this later, I know. How would you deal with a new casual employee? I guess actually it doesn't have to be a casual employee, it could be a permanent employee who goes off sick before they've worked a full week in order for you to calculate the weekly SSP rate. Would you just do a straight pro rata or
Wow, that is a great question.
that
Um,
might be one we need to come back to you on then?
yeah, and speak to our payroll colleagues because how would it be done now?
Yeah,
Yeah,
I guess the answer would be that if it was within the first week, you just have to prorata the weekly figure by the number of work days and the pay for those work days in the first week.
yeah. I mean, if they've worked one day and a couple of hours, that's there, and then you do 80% of that.
Yeah.
That's what they will receive.
Okay. When is the new SSP rule coming into force?
6th of
And here,
April.
right. Do we include trunk in the calculation of average pay? Great question. Don't know. Will depend to an extent on the outcome of the Big Table Employment Tribunal appeal, which isn't expected to be heard until the end of the year. Um, Even then, it's not going to be crystal clear. I am reliably informed by people in a position to know that the government and officials at DBT intend to watch that tribunal appeal very closely because of the various ramifications that it may have on that. So the answer at the moment is we just don't know. Next one, and Claire, I think I know the answer to this one, but just to be clear, if an employee calls in sick and they're off sick for one day, are they automatically due SSP or do they need to request it? Is the onus on the employer to process every sick request as an automatic entitlement to SSP? We have a lot of young adults and teens who regularly call in sick on a Monday and Sunday, for example.
Yeah, I think we all know the answer to this. The onus is very much on employers. It won't be on an employee to request SSP. If they are off sick for one day, they will be paid and receive SSP. Which is why, we talked about looking at everyone's absence policy, your triggers, what are you tolerating as a business? If you have a lot of young employees that perhaps are hungover and decide not to come to work. And we've tolerated that for months or years. Now is the time to draw a line and refresh your absence procedures. But equally, again, I refer to some of the discussions yesterday at the UKH event. There are businesses that have a lot of young people, and they'll swap their shifts. If someone wakes up on a Monday morning and says to their mates, "Can you do the shift for me?" That that is the flow of the business, and that's become the norm. With the changes coming in next year for changes to shifts and reasonable notice and 0 hours, how you operate now might not be acceptable come the new when the new measures are brought in for reasonable changes to shifts. So that's a real watching brief. But in answer to the question, yes, unfortunately, SSP is paid and it will have to be processed by us as employers.
And one question as well, can we help businesses in designing SSP policies? I'm guessing
Absolutely.
the answer is yes,
Yes. Yeah.
is the right answer. Super. Okay, I think let's have a look. Okay. There's a couple of questions on irregular hours for SSP. I think what we may do is take those away and maybe feedback with a more detailed one. What we don't have is any of our payroll colleagues on the call this morning. That will be more one for them to deal with the mechanics as opposed to the policies and the obligations, the practicalities. I think that might be something that we could get some input from them in to do that. Okay.
Yeah, definitely.
Okay. I think we've covered all of the different ones. One last one. If an employee doesn't give us a self-certification, can we deal with the absence as unauthorised and unpaid?
Yes, if they're not following your process, and your process in terms of self-certification and sick note doesn't change, and if they're not providing a self-certification form, then yes, absolutely.
And I guess that comes back to then how good your policy is, and how clear you are explaining to your staff, what they have to do in the case of sickness.
Yeah, and I think this is again where communication to your employees plays a huge part. They will be watching the news. They're well aware of a lot of these changes coming in. So again, it's about being proactive and not being back on the back foot, and using this opportunity as a reminder of your sickness and absence policies, certainly for April.
Brilliant, Claire. Thank you. Thank you for coping with all of those questions. I very much threw at you there as well. Thank you all as well for your time this morning. Just to trail our next two hospitality webinars. 26th of March is the national minimum wage, but specifically it's the national minimum wage as it relates to salaried workers or people who you may consider to be salaried workers. Now, in their enforcement of minimum wage, Revenue and Customs have been doing a lot of work and are going to be ramping up work with regards to what they see as extra hours, unpaid hours worked by people who businesses are treating as salaried. The rules regarding salaried workers for minimum wage are complex. They're not particularly logical, and it's very, very easy for a business to fall foul of these. So we're going to be having a deep dive into this specific issue. And once the Fair Work Agency gets up and running later on this year, we know that this is an area that they are already going to be focusing on as well. So that's a key one. Then on the 22nd of April, immigration, the thorny issue of immigration. So clearly there's been lots and lots of changes over the last couple of years in the whole sphere of immigration, in the sphere of visas, in the sphere of earnings levels, skilled workers, so on and so forth. And obviously as a sector that has a significant proportion of workers who may be non-UK, it's a really, really important issue and question. What we are seeing and what my colleagues who specialise in this area are now seeing is there is now real-time sharing of information between Revenue and Customs and the Home Office and the Border Agency. What that means is your payroll information will get to the Home Office once you submit it. And we've already seen examples of businesses who've had their sponsor licenses revoked because of information that was sent to Revenue and Customs as part of payroll. So really important. I'll be joined on that by a couple of my colleagues from our immigration team here in Wilkinston Smith as well. And as Claire says, if we get further details on things like the 0-hour changes, we'll also slot in some more as well. So please keep an eye out for the invitations. Other than that, the last thing really from me is firstly, Claire, to thank you for giving a very clear, very thorough explanation as well with that. And thank you everyone to logging on and joining us this morning. I hope it's been useful. And we will see you hopefully again next month. Thanks, everyone.
Thank you, everyone.